Yes. Mr. Monning, you're up next.
Good morning, Mr. Chair, members. I have two bills, both candidates for suspense. If I could, I'd like to start with SB 260 with the permission of the chair. I have SB 260 and SB 253.
Please proceed.
Thank you very much. Good morning, members. Senate Bill 260 requires that all county organized health care systems plans be licensed by the Department of Managed Health Care under the Knox-Keene Act to ensure that all Medi-Cal plans are under a single standard of regulation and that those Medi-Cal beneficiaries are afforded with all the same consumer protections that come with licensure. Amendments taken in the Assembly Health Committee delay the bill's implementation to give COS plans ample time to comply with licensure. As the analysis points out, the licensing fees and administrative costs for the COS plans are fully reimbursable, and more than half of these costs will be reimbursed by the federal government. While there will be state costs to require licensure, these costs are well worth the Knox-Keene protections they bring for the 2 million people that will receive Medi-Cal through COS plans. Right now, these protections are provided to all other Medi-Cal beneficiaries and enrollees in commercial plans. Furthermore, COS plans are the recipient of state funds to administer managed care exclusively to that population, and as such, we should make sure that these taxpayer funds are used wisely and the care provided is adequate. I would also agree with the analysis point that Knox-Keene regulation of COS plans could assist in streamlining the duties of DMHC and DHCS. Members, the time has come for the COS plans to be regulated like all other Medi-Cal plans in California, and the protections afforded are well worth the cost for the 2 million people in COS plans. Here to testify in support and comment on the fiscal issues in this bill, Elizabeth Landsberg, Western Center on Law and Poverty, and Tom Ma, Health Access California. Thank you, Mr. Chair.
Let's keep it brief. These bills are on suspense.
Mr. Chair and members, Elizabeth Landsberg with the Western Center on Law and Poverty. We are supporting this bill because we're sponsoring this bill because we think it is important that all Medi-Cal beneficiaries have access to the same consumer protections. We believe the costs and the analysis are on the high end. As noted, Medi-Cal members whose plans are licensed by the Department of Managed Health Care tend to call the help center a little bit less frequently than other people. The bulk of the costs for the Department of Managed Health Care are those help center costs. But if the department is right and people need that many staff to help them with problems, then we think that the cost is well worth making sure people get the help that they need. We agree that DMHC and DHCS are doing a better job streamlining and that this will help. We also would note that more than half the cost of the bill will be paid for by federal Medicaid matching dollars, but we think some general fund cost is worth the uniform protections and oversight, and appreciate your consideration coming off suspense. Thank you.
Good morning, Mr. Chair and members. Tam Ma with Health Access California here in strong support of the bill. This bill is about equity for people who are enrolled in Medi-Cal managed care plans. 2 million people are enrolled in COS plans, and the state spends $4 to $5 billion a year and pays COS this amount to provide coverage for these individuals. Even if it costs $4 million a year to get DMHC licensure for these 2 million people, this amounts to 0.1% of the money that the state is spending to provide coverage for these $2 million individuals. We believe this is a small investment that provides critical consumer protections, the same protections that are available to millions of other Medi-Cal managed care consumers, and we urge your support of this bill when it comes off suspense.
Thank you so much.
Thank you. Melissa Cortez Roth on behalf of Autism Speaks and the Center for Autism and Related Disorders. And I just want to note that the state is in the process of transitioning kids with autism from regional centers into Medi-Cal managed care plans, and we think it's critical that those kids going into COS plans have access to the same treatment, to independent medical review as well as network adequacy.
Thank you. Individuals from the public in support.
Bernadette Ariano on behalf of the California Children's Hospital Association in support.
Great. Witnesses in opposition.
Thanks.
Mr. Chair, members. Rob Lane with Partnership Health Plan of California.
Briefly, please.
Why we have the highest respect for Senator Monning, we are opposed to SB 260. We are not opposed to regulation because, let me be clear, we have a regular 2-week annual audit from Department of Healthcare Services and the Department of Managed Healthcare. We pay fees, sign contracts, hundreds of pages long, and we have a strong working relationship with both departments. We are opposed to changing our decades-old model of care and adding significant administrative costs and bureaucratic burdens during the time where both departments are, as stated in your analysis, involved in a multi-year effort to eliminate redundancies. This bill will cost Partnership alone over $1.8 million. There have been discussions about this being reimbursable, but the reality is that those upfront staffing and filing costs are ours to absorb. This will only be built into our rates after 2 years, but the startup cost will be not part of that calculation. Mr. Chair, I respectfully ask you to consider how you want to spend this money. Do you want to spend it on fees, duplicative administrative filings, or things like glasses, podiatry, and transportation?
Thank you so much.
Catherine Reese with Public Policy Advocates on behalf of SenCal Health, which is a county-organized health plan that serves San Luis Obispo and Santa Barbara counties. We would echo what has already been testified. We would make one additional point. The testimony by the proponents would make it sound as though we are unregulated. Virtually 95% of all of the Knox-Keene requirements are contained in our contracts. And those 2 or 3 areas where the proponents feel there should be some modification, such as independent medical review, is easily handled through our contracts or through an additional piece of legislation that would, but not spending $4 million to impose duplicative regulation and compliance on us. That money should go to those who need health care, not transferred from one department to another to impose duplicative regulation and governance. Thank you.
Thank you so much. Individuals from the audience in opposition.
Mr. Chair and members, Trent Smith on behalf of Cal Optima, Gold Coast, and Partnership Health Plans in opposition.
Thank you.
Karen Lang on behalf of the Solano County Board of Supervisors in opposition. Thank you.
Great. Department of Finance.
We do not have a position on this bill. Cost to the Department of Managed Healthcare is estimated at $4.9 million from the Managed Care Fund annually. And because the state's general fund is responsible for the non-federal share of increases in capitation rates, this bill would eventually increase general fund spending by up to $1.5 million annually.
Thank you so much. Questions or comments from the committee members? Seeing none, would you like to close?
Just briefly, when this comes off suspense, or as it's considered to come off suspense, I'd urge your aye vote. And just to underscore, the plan's costs are reimbursable, partial state costs reimbursable through the feds. This is good policy. It protects consumers. Would urge the aye vote at the appropriate time. Thank you.
Thank you so much. Your next bill?
Yes, this is SB 253. And Mr. Chair, members, I know that this SB 253 is also a candidate for suspense. Briefly, SB 253 strengthens the juvenile court's process for authorizing psychotropic medication use by foster children. This is a part of a suite of bills with Senators Bell and Mitchell. This bill mandates the application of health care standards by the judiciary when authorizing psychotropic drugs to children in foster care. No psychotropic drugs would be authorized without prior medical exams of the children, and ongoing monitoring must occur. For treatments with the greatest risk, a second opinion from a psychiatrist must be obtained. The data is very troubling, members. Nearly 1 in 4 foster youth receive powerful psychotropic drugs. Of all the children taking psychotropic medications in California, of all children, 52% who are given antipsychotics which have risk factors that can lead to lifelong disabilities such as tremors, obesity, and diabetes. 48% of foster youth are given antidepressants that have an FDA black box label warning for use by children. We, the state of California, assume the role of the parent for foster youth. It is the job of the legislature to address this problem for a voice that doesn't often get heard. SB 253 seeks to address this issue. I respectfully ask for an aye vote when suspense is considered. Thank you, Mr. Chair. Members, we have a couple of witnesses in support. Thank you.
Thank you so much.
Good morning, Mr. Chairman and members of the committee. My name is Tisha Ortiz. I am 22 years old and a student at Cal State East Bay and an advocate at the National Center for Youth Law. I entered into the foster care system with a lot of problems from the abuse I went through, sexual, physical, and emotional trauma. When I was in care, I experienced being overmedicated with 4 different psychotropic medications. This consisted of me taking 12 pills a day, 6 in the morning and 6 at night. If I had a judge to review my case, he would have noticed the negligent practice and would have uncovered that I was on too many drugs at too high doses for too long. A judge would have been able to have my trauma history, my medication history, and medical records, and would have checked to see if I was getting other mental health services to treat the symptoms of my trauma instead of me being in a zombified phase throughout my high school and a young adult life.
1 minute.
Over-medicating foster youth is costly for the state of these medications. They cost a lot. Using other services like TBS, therapeutic behavioral services, or trauma-focused therapy show better outcomes instead of using millions of dollars for a dangerous cocktail of medication being paid by Medi-Cal. SB 253 is important for addressing this crisis and curbing the over-medication of foster youth. Please support SB 253.
Thank you so much.
Thank you, Chairman and members of the committee. National Center for Youth Law is a sponsor of this bill. This bill is critical for making sure that when a judge authorizes a medication for a child, it's in their best interest, and that the trauma history, the medication history, and other treatments have been looked at first before signing off on a costly medication. We've made reductions in the cost of this bill, and we urge your support when the time comes. Thank you.
Thank you so much. Any other individuals from the public in support? Just your name, organization, and position.
Alan Hertzfeld on behalf of the Judicial Council in support.
Rochelle Trottenberg, former foster youth, and I strongly urge your support.
Rebecca Gonzalez, National Association of Social Workers, California Chapter in support.
Frank Mecca, County Welfare Directors Association in support.
Robert Sumner, Attorney General Kamala Harris in support.
Nicole Wertelman, Alameda County Board of Supervisors in support.
Khalif Asagай, Children's Defense Fund, California in support.
Thank you so much. Witnesses in opposition?
Thank you, Mr. Chair and members. Christopher Castrillo on behalf of the California Academy of Child Adolescent Psychiatry. We do have outstanding policy concerns as noted in the appropriations analysis, and we hope to continue those conversations with the author and the sponsor. Thank you.
Thank you.
Mr. Chairman, members of the committee, Randall Hager for the California Psychiatric Association. We're still working with and do appreciate the continued work of the author and the sponsors on some policy issues that have to do with operationalizing this really important bill, because it has the potential also to impede the access of medications to children for whom they're medically necessary. Thank you.
Thank you.
Good morning, Adrienne Shilton with the County Behavioral Health Directors Association. We represent the public behavioral health authorities in counties throughout the state. We also expressed concerns with this bill as noted in your Appropriations Committee analysis, and we look forward to working with the author and sponsors on those issues. Thank you.
Great. Any individuals from the public in opposition? Department of Finance?
No file.
Questions or comments from the committee members? Seeing none. Would you like to close?
Respectfully ask for your aye vote at the appropriate time on suspense. Thank you, Mr. Chair. Thank you, members.
Thank you so much. Mr. Leno, you're up. You have 7 bills before us, but 7 bills on suspense. Please do not feel obliged to present on all your bills.
Mr. Chair, committee members, I am prepared to waive presentation on SB 178, SB 441, SB 518, and SB 546, and then I'm prepared to make you a deal that if the opposition on SB 3, SB 124, and SB 763 also agree to waive, I'm prepared to waive.
Are people? That sounds like a deal. If they can still present. So are you guys good to waive on all three? Okay, perfect.
All right. Thank you very much for your time.
Thank you so much.
Okay.
Senator, you just became the most popular senator. Senator Glazer, you're up. Senator, you have one bill with the due pass recommendation, SB 539. Please begin.
Thank you, Chairman Gomez and members. Our public buildings should be named for people of great accomplishment who are role models of high morals and principles. Unfortunately, some public places in California still honor Confederate leaders who attempted to break America in two to protect their right to enslave black people. I don't want to erase their names from our history books. I just don't want our children looking up to people who fought to preserve a system that treated human beings as chattel. That's the basis for my legislation, SB 539, the Frederick Douglass Liberty Act, which seeks to remove the names of elected and military leaders of the Confederacy from all public places, including street signs and schools. With the help of committee staff, we've identified a small number of public properties bearing Confederate names, 3 elementary schools. As noted in the analysis, because of the small number of properties, any cost to the state is expected to be minor. I'm appreciative that the measure enjoys bipartisan co-authors. Thank you for allowing me to present and ask for an aye vote.
Thank you so much. Any witnesses in support? Individuals from the public in support? Witnesses in opposition? Individuals from the public in opposition? Department of Finance?
No file.
No file. Questions or comments from the committee members? We have a motion and a second. Would you like to close?
Ask for an aye vote. Thank you.
This bill is out on a B roll call. Chang, Wagner, aye. Thank you so much.
Thank you.
Mr. Hertzberg, you're up. Mr. Hertzberg, you have 6 bills, 1 due pass, SB 272, 3 on suspense, and 2 consent items.
That's right, and it's being inspired by the great leadership of Chairman Leno. Certainly I'll waive presentation on SB 233, 239, and SB 621. And, of course, I believe on consent is SB 540 and SB 697. And I believe there's no cost associated with the only measure that's up today, which is SB 272. And I, too, would waive presentation
Move
since
approval.
there is no cost. As long as the opposition chooses to do the same.
Mr. Hertzberg, quick clarification. SB 233 is on the calendar for next week.
I'm sorry. 233 is on the calendar for put over. I'm sorry. I saw that
Put
note.
over.
Yeah. Put
Thank
over
you.
for next week. That's correct.
Thank you so much.
That's probably Mr. Reyes' mistake.
So SB 272, we have a motion and a second. Witnesses in support. Individuals from the public in support. Witnesses opposition. And are we... Okay, 272.
Just to announce ourselves, Mr. Chairman, Gilto PD with the California Municipal Utilities Association. We recognize that there are no state costs. Our concern is about unintended costs by including in the bill's description of the 7 listed discrete items of information to be on the enterprise catalog. If that information is online, we believe that increases the likelihood of some cybersecurity risks. The unintended costs to local governments could be borne on them should there be a compromise to the utility systems. Thank you, Mr. Chairman.
Thank you so much.
Mr. Chairman, my apologies for being late. Michael Shaw, California Manufacturers and Technology Association, in support of SB 272. I believe that making this information available is important for understanding. It helps develop additional tools that can be useful in economic development, public health, public safety, and additionally, as far as manufacturing is concerned, better understanding about siting facilities and growth, opportunity to create jobs. And we believe this is an important step in that direction, making that information available to the public and understandable. Thank you.
Thank you. The rest, just your name, organization, and position. Thanks.
Thank you, Mr. Chair. Members, Megan Brightwell on behalf of the California Professional Firefighters, pleased to be in support.
Great.
Yolanda Benson, representing the California Asian Pacific Chamber of Commerce, also in support.
Thank you.
You take an opposition at this time?
Opposition.
Dylan Gibbons with the California Special Districts Association, currently in opposition to the bill, but working with the author's office, reviewing amendments right now, which we hope will remove our opposition. So I'd like to thank the author for his work on this bill and turn over to the rest of the opposition.
Thank you so much.
Alicia Lewis with the League of California Cities, as well as California State Association of Counties. Not used to mentioning them. But either way, we are mirroring the same comments. We are thankful to the author for moving forward on the amendments and discussions we've had, and we think that we're in the right direction to remove our opposition.
Thank you.
John Lovell with the California Police Chiefs Association. We would incorporate by reference the comments of the two previous witnesses and commend the author for his working with us.
Thank you so much. Department of Finance.
We have no position on the July 6th version of the bill, no fiscal impact to the state.
Great. Questions or comments from the committee members? Mr. Bigelow.
Thank you. Mr. Hertzberg. That was very encouraging to hear some of those comments. My question was going to center around: Are you going to continue to follow up with some of the comments and concerns that were raised with respect to the cybersecurity issues by honing in more specifically into key elements versus maybe the way it's bluntly put today? So the California Police Association and a number of others who have come out have a position of opposition or would like to support it if amended. Are you able to work with them and get that done?
Well,
or make that kind of commitment that you're working with them?
Well, look, I got to tell you, it's a little frustrating. First of all, the law already says right now in the government code that nothing shall be construed to require the disclosure, this relates to public records, of an information security of record of a public agency if, on the facts of a particular case, disclosure of that record will reveal vulnerabilities to or otherwise increase the potential for an attack on or information technology system of a public agency. Okay? That is the law. Now, I think it's pretty clear. But when you deal with local governments, and now being chair for the first time of this local governance and finance in the other house, everybody's got an opinion, and it's kind of interesting. But I've taken 12 amendments to try to deal with it, whether it's utilities, whether it's clarified the specific records are not to collect or store, exchange, or analysis, the timelines for compliances, excluding infrastructure controls for traffic lights, waters, and sewers. I've excluded physical systems, employee identification systems, video monitoring systems. I've expanded to exclude school districts. I've excluded everything. I've exempted 911 and emergency systems.
Move the bill.
There's about nothing left. So, yeah, I'm working with the cats, but it's a little much to cut to the chase. It's like negotiating a deal and you give them 99.9% and they come in and tell you we still oppose. Enough already. But if I can do it, I'll do it.
And I appreciate that. I know
still have anything left, because you know the game. It's like we'll give you a bill number, but it don't mean nothing. I didn't come to do that.
Totally understand it and respect it, but as you know, cybersecurity has become a really huge issue, and it's very difficult. State laws and federal laws have many conflicts, and that's the simplicity of the question that's trying to be resolved. Can we work? And I think that's what I heard from you, a willingness to work to resolve the issues between the federal and the state conflicts.
Yeah.
Thank you. I appreciate that, Mr. Hertzberg.
Thank you, sir.
Okay.
Thank you. Any other questions or comments? Seeing none. Was that your close?
That's it.
Thank you. We have a motion and a second. This bill is out on an A roll call.
Thank you very much.
How do you like that, sir?
Appreciate it. Thank you.
Assemblymember Wachowski, come on up. Oh, sorry, Senator Wachowski.
Hey, it's all right.
You have 6 bills, 2 do pass, 1 suspense, and 3 consent. Your do pass recommendations are 383 and 641. How would you like to proceed?
I'd like to waive presentation on the suspense bill 246, and I'd like to proceed with 383.
Thank you so much.
This is a result of a productive collaboration with the plaintiffs' bar, the defense bar, and the Judges Association to improve California's demurrer process. The bill creates a mandatory meet and confer process that may be held in person or by telephone, in which both parties provide specific legal authority to support their pleadings or demur in order that the plaintiffs may come to an agreement in ways that will prevent them, avoid going into court for a hearing. As your analysis notes, the bill will not have significant impacts on the courts and will likely save money in the long run. I have representatives from all 3, or from 2, the plaintiffs' bar and the defense bar, and I urge an aye vote.
Thank you. Please proceed.
Mr. Chair and members, Mike Belote on behalf of the California Defense Council and the California Judges Association. There's a robust policy debate going on with the opposition, but here's the fiscal issue. The courts have lost over $1 billion in recent years in court funding. No one's fault. Big recession that had to be worked through. But we have, and most of those impacts.
Move the bill.
Okay. Most of those impacts have fallen on the civil system.
Second by Calderon. Please continue.
This is a chance with no cost to perhaps save the courts some money and help the budget situation. Judges and defense lawyers, the people who really do this, believe that a meet and confer, which is often required informally now and is required in the federal system, can help eliminate some demurs. Demurs are expensive and time-consuming for everyone, clients, judges, lawyers alike. If we can reduce some demurs, we save the courts money, we handle civil cases more efficiently. We're not saying it's the magic bullet, but it is certainly worth a try. We put a sunset clause on it to see if it works. We would ask for permission to try this sensible civil efficiency and ask for an aye vote.
Thank you so much.
Good morning. Nancy Drabble with Consumer Attorneys of California. We have worked out language which we really do think will save both the courts and the litigants time and money, which is absolutely essential given the court budget cuts and the pressures that have been put on the system. This is not an ideological bill. This is something that will actually help the courts in trying to eliminate some unnecessary motions and some amendments that otherwise could be made without taking up the court's time. Thank you.
Thank you so much. Individuals from the public in support? Witnesses in opposition?
Catherine Pettibone with the Civil Justice Association in opposition to this bill. It's unusual to find ourselves on the opposite side of the table of the Defense Council, but our members, who are also the ones who pay for attorney's fees bills and who have to pay to litigate in this state, are opposed to this measure. Everybody would love to see streamlined procedures. Look, if we could stop needless filings, including claims, motions, etc., that's going to help our businesses. Unfortunately, the response we've got on this bill is that they feel like it's going to kick the can down the road. The meet and confers are not going to actually achieve what we would hope they would achieve, and then we're going to end up before the court anyways. There's a couple of problems with the bill that was dropped into judiciary about waiving general demurs. That's another issue. We strongly support reducing needless motions, needless claims. Again, our folks have to defend them. We would love to work with the author on a 2-year process where we look at all the different motion practices. How come these claims are coming to the court in a mess so that we have to file demurs? When we sponsored 2494, the sanction bill, that bill would have addressed this kind of nuisance demur thing that we're hearing about. That bill was opposed by the consumer attorneys who said we have existing sanction law to stop frivolous motion and filings in the court. So we are not convinced that the sanction practice won't actually address this issue that we're trying to fix with this bill.
Jennifer Brewer on behalf of the California Chamber of Commerce. We echo the concerns of CJAC. We, too, are advocates for additional funding to our court system and believe that it's necessary. However, we do not believe this will create any cost savings. The proponents of the bill say we should just try this and see if it works. The meet and confer process is already prominently utilized in the discovery. Discovery meet and confer, if you fail to do it in good faith, actually has sanctions associated with it. And that process, I can tell you from personal experience of litigating for 9 years, as well as hearing from our litigators, has not achieved any greater resolution of discovery issues. There's still motions to compel. It's a significant pleading and motion requirement in our civil litigation system. And that's when attorneys are threatened with sanctions if they don't meet and confer in good faith. So I don't think we need to study this. I think there's already effective data out there that shows it's not an effective process. And we don't believe this will achieve any cost savings to the court system. It will just simply increase the cost for our clients who are paying for civil litigation. So we, too, are opposed to this bill. Thank you.
Thank you so much. When individuals from the public in opposition?
Rodney Wilson on behalf of the California Credit Union League, also in opposition.
Mr. Chair, Member Shane Levine on behalf of the Cooperative of American Physicians, also in opposition.
Kara Cross on behalf of the Personal Insurance Federation of California, also in opposition.
Department of Finance?
We have a neutral position on the July 9th version of the bill and no fiscal impact.
Thank you. Questions or comments from the committee members? Mr. Wagner.
All right. I find myself in the strange position of just respectfully having to disagree. As a practitioner who has brought and who has defended numerous challenges to complaints, I just don't see the downside. I think you may very well be right that this is not a silver bullet. It won't significantly reduce the number of demurs or the number of hearings that a court has to have. But if it cuts them down just a little bit, we're ahead of the game because by definition you're incurring no additional attorney's fees. If you're going to bring your demur, you have to do the research that would go into the meet and confer anyway. So I don't see you ginning up additional attorney's fees more than maybe the de minimis amount for the phone call itself. I disagree on the point that sanctions in discovery hasn't cut down discovery disputes. It hasn't eliminated them. No question it hasn't eliminated them. I don't expect this measure to eliminate demurs, but it has significantly reduced the number of discovery disputes you otherwise have because there is a real downside to it. The senator might want to consider putting some sanctions into this bill or the next version of this bill that kind of mirrors the discovery sanctions because I do truly believe them to be effective. Let me say the one objection that I would like to hear you address, and you and I talked about this offline, the waiver of general demurs. Is that intended in this bill or not? I think that is troubling, but perhaps not fatal to me because, okay, I've waived a general demur, but I can always turn around and do a judgment on the pleadings and get to the same place.
Right.
But if I can get to the same place, why do the waiver in the first place and muck up existing law? So I'm inclined to support the bill, but I still have that problem.
I'll have the fence bar comment. We will note that we amended this bill to make it a 5-year bill to sort of to come back to see how it works because everybody's has such a great interest in it. But Mr. Belote.
Mr. Chair, and Mike Belote again on behalf of the California Defense Council. We have heard that argument and on general demurs, and we will talk about that. There is this language in the bill that says you cannot later demur on something you could have included in your first demur, and the defense bar believed that was a fair compromise, that because there was a contention that defense lawyers were holding back arguments they could have used and using repetitive demurs, and that's not good for the system. But we will look at that question of the waiver of general demurs.
What does that mean? This is the last stop for the bill before it hits the floor.
There's still some additional issues that we're talking about, including a limitation on the number of amended complaints without a showing of good cause. So there are some final tweaks that we're working on the bill that are non-fiscal that we're discussing with the plaintiff's bar and with the opposition.
Do you agree that even with that language in the bill, if for whatever reason it doesn't change, the opportunity to challenge a pleading, perhaps not on demur, but on a judgment on the pleadings or at some later point, for things like jurisdiction, things that usually find their way into a general demur, those remain?
Yes.
Available?
Yes. We agree that those are available.
Yeah.
There was discussion of also including motions for judgment on the pleadings, motions to strike, and that sort of thing, because there's lots of ways to style these objections. We think those are preserved.
Okay.
It's not fatal.
Thank you. Mr. Bloom.
Thank you. It sounds to me that there's a certain amount of experimentation that's going on here. We want to try this out and see how it works. And if that's the case, then I would suggest that it ought to be conducted as a pilot project in a limited number of jurisdictions.
The judges don't want that. But thanks for the suggestion.
Thank you. There's a reason why I'm not on judiciary. That's a good thing. This is a fiscal committee. We're going to focus on the fiscal impact, and our analysis says it's insignificant cost to the courts and judicial council, possible minor administrative cost savings if the revised procedures result in fewer court hearings. So we have a motion by Quirk, a second by Calderon. This bill is out on a B roll call. Chang not voting. Gallagher, aye. Wagner, aye. Thank you so much.